What was the conflict among American colonies that led to the right to freedom of religion? And what does religious freedom mean for you? Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Today's story has its roots dating back to 1534, when King Henry VIII formed the Church of England, which is the country's national church. Also known as the Anglican Church, the Church of England maintained traditions closely similar to the Roman Catholic Church. Between 1620 and 1640, there was a steady exodus of Puritans who were unhappy with these traditions and so emigrated to Massachusetts and the neighboring colonies, during which what is known as the Great Migration. Many ministers also reacted to the repressive religious policies of England and made the trip to the New World with their congregations. Hello, good people. My name is Janice, your host here at Dignity, Human Rights in Daily Life. Thank you for stopping by. If you're new here, welcome. After watching this video, I invite you to check out this playlist and please consider subscribing. The Massachusetts Bay Company was formed by a group of small investors to fund the Great Migration. Colonial founder John White was a rector of a parish in Dorchester, Dorset, England, and was instrumental in obtaining a charter so that the Massachusetts Bay Company could establish the Massachusetts Bay Colony. Although White never sailed to America himself, as preachers tended to do, he did send a colony of Dorset men to settle in Massachusetts, allowing nonconformists to enjoy civil and religious liberty. Anne Hutchinson was famous as one of the early colonists of the Massachusetts colony. Growing up, she learned from her deacon father to question the religious teachings of the Church of England. Hutchinson and her husband Roger Williams followed Protestant minister John Cotton to Massachusetts. There, she shared her own interpretations of Cotton's teachings against the precepts of the governing ministers. Tried by the General Court, she was found guilty of heresy and was banished from Boston. Her husband, Roger Williams, was a Puritan minister, theologian, author, and a staunch advocate for religious freedom, separation of church and state, fair dealings with the indigenous peoples, and was one of the first abolitionists. As a separatist, Williams considered the Church of England irredeemably corrupt and believed that one must completely separate from it to establish a new church for the true and pure worship of God. His brand of liberty of conscience got him expelled by the Puritan leaders from Massachusetts Bay Colony for spreading new and dangerous ideas. White went on to found Rhode Island and to establish the First Baptist Church in the New World. William Penn was an early advocate of democracy and religious freedom. After King Charles II handed over a large piece of his American land holdings to Penn, which is now Pennsylvania and Delaware, he arrived in Delaware where the colonists pledged allegiance to Penn as their new proprietor, and the first General Assembly was held in the colony. His Quaker government was not viewed favorably by the Dutch, Swedish, and English settlers, and with no historical allegiance to Pennsylvania, began petitioning for their own assembly. As one of the earlier supporters of colonial unification, Penn wrote and urged for a union of all English colonies in what was to become the United States of America. The democratic principles that he set forth in the Pennsylvania frame of government served as an inspiration for the United States Constitution. Peter Stuyvesant was a scholar and attended university to study languages and philosophy. Eventually, he joined the Dutch West India Company, which selected him as the Director General of the New Netherland colony, present-day New York State, which included New Amsterdam, the site of present-day New York City. As a member of the Dutch Reformed Church, Stuyvesant opposed religious pluralism and came into conflict with Lutherans, Jews, Roman Catholics, and Quakers as they attempted to build places of worship in the city and practice their own faiths. When the Quakers were newly arrived in the colony, Stuyvesant ordered the public torture of a Quaker convert who had become an influential preacher. He then made an ordinance punishable by fine and imprisonment against anyone found guilty of harboring Quakers. That led to a protest from the citizens of Flushing in the borough of what's known as Queens today, which came to be known as the Flushing Remonstrance, a precursor to the United States Constitution provision on freedom of religion in the Bill of Rights. To learn about the backstory on the formation of the Bill of Rights, check out the first video in this playlist on the U.S. Bill of Rights and Human Rights. Although Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, it is the United States Supreme Court that decides the parameters of what religious freedom means. In 1862, President Abraham Lincoln signed into law the Morrill Anti-Bigamy Act, which banned bigamy in federal territories such as Utah, and the act targeted the Mormon religious practice of plural marriage. Fast forward to 1874, when George Reynolds, a Mormon, married his second wife and then volunteered to serve as defendant to challenge the constitutionality of the act. Mr. Reynolds provided the United States Attorney with witnesses who could testify that he had two wives. He was indicted for bigamy by a grand jury and in 1875 tried, sent to prison, and fined $500, the equivalent in 2019 dollars of over $11,500. After the Utah Territorial Supreme Court upheld the sentence, the case made its way before the United States Supreme Court as the first landmark case on the free exercise of religion. The United States Supreme Court examined whether the Morrill Anti-Bigamy Act, a federal statute, violated the First Amendment's Free Exercise Clause because plural marriage was part of the Mormon religious practice. The court unanimously upheld the federal law banning polygamy, noting that while the Free Exercise Clause forbids government from regulating belief, it does allow government to punish criminal activity. Unemployment compensation is paid by the state to unemployed workers who have lost their jobs due to layoffs or retrenchment. In most states, employees are disqualified from unemployment benefits if fired for misconduct, willful behavior, or other justifiable or good cause. Adele SHERBERT was a member of the Seventh-day Adventist Church who worked in a textile mill. Saturday was her Sabbath. Eventually, her employer switched from a 5-day to a 6-day work week that included Saturdays. In accordance with her religious belief, working on Saturdays was forbidden, so she refused to work that day and was fired. Ms. SHERBERT could not find any other work and applied for unemployment benefits. The Employment Security Commission denied her claim, which a state trial court and the South Carolina Supreme Court upheld. The U.S. Supreme Court examined whether the state of South Carolina violated Free Exercise Clause by denying unemployment benefits to Ms. SHERBERT or turning down a job because it required her to work on her Sabbath. In rendering its decision, the U.S. Supreme Court created a two-pronged test known as the SHERBERT test to determine whether the government violated the Free Exercise Clause. It found that South Carolina statute impeded Ms. Sherbert's right to freely exercise her religion because the government could not demonstrate both a compelling interest and that the law in question was not narrowly tailored before it denied unemployment compensation to someone who was fired because her job requirements substantially conflicted with her religion. S. Simcha Goldman entered the United States Air Force as a commissioned officer and clinical psychologist at an on-base mental health clinic. An Orthodox Jew and rabbi, Mr. Goldman's faith required him to wear a yarmulke to show that he is aware that God is a higher power and above him, and he wore it under his service cap. When Mr. Goldman's colonel advised him that he was in violation of an Air Force regulation, he sued the Secretary of Defense and sought to apply the SHERBERT test. The court, however, found that the SHERBERT test did not apply because the Free Exercise Clause did not generally apply to the military in the same way it did civilian society, because the Air Force's purpose in its dress regulation is uniformity, and it reasonably and even-handedly regulates dress in the interest of that need. The court decided that the First Amendment did not prohibit the Air Force from applying the challenged regulation to the wearing of a yarmulke by a soldier on duty and in uniform. In 1986, President Ronald Reagan signed a bill allowing members of the armed forces to wear an item of religious apparel while in uniform. Do you think these Supreme Court decisions were fair? Let me know in the comments. Learn about other clauses in the First Amendment here. Mark #Team Dignity in the comments. Like, share, subscribe if you haven't already. And in the meantime, be well and remember to live your life with dignity. Bye-bye.